So you're trying to comply with your CTA requirements, but you're having problems getting information from a beneficial owner. You know the one, that one. What do you do? And what's the worst that can happen if you submit wrong or incomplete information? I'm going to go over these scenarios and we'll see what FinCEN has to say about them. And stick around to the end of the video for a free offer from yours truly that should help you get started in terms of communicating with your beneficial owners about your reporting requirements. Hi, guys. Welcome back to Presume Legal. I'm Misha Janice. I'm an entrepreneur and an attorney licensed in New York and Florida. Welcome to my channel. Thank you for joining me. Today, I want to go over a situation that I can see happening so many times. It's going to happen. It's going to be where you have a beneficial owner that you're trying to get information from, and they're just putting up resistance, or maybe you can't find them. Maybe they are MIA. Who knows what the situation may be? What do you do in that situation where you have a reporting requirement, but you're not able to submit full and complete information, either timely or you're just not able to submit that information entirely? Let's go over to the FinCEN.gov website, which is where FinCEN, which is the financial enforcement and oh my gosh, the Financial Crimes Enforcement Network, the Financial Crimes Enforcement Network's website, where they publish FAQs answering questions like these. All right, so let's go through these questions that they've published with their answers on how to handle certain situations, right? Let's get right into it. First question: what happens if a reporting company does not report beneficial ownership information to FinCEN or fails to update or correct the information within the required time frame? Now, we know that for companies that have been formed before January 1, 2024, they have a full year to comply with their reporting requirement. So they'll have until December 31st, 2024 to submit their initial BOI report to FinCEN. For companies that are newly created in 2024 and in 2024 only, from the date of creation, they'll have 90 days to submit their initial beneficial ownership information report to FinCEN. So this question is asking, what happens if they're unable to update or correct the information within the required time frame? Answer: FinCEN is working hard to ensure that reporting companies are aware of their obligations to report, update, and correct beneficial ownership information. FinCEN understands that this is a new requirement. If you correct a mistake or omission within 90 days of the deadline of the original report, you may avoid being penalized. That's that 90-day safe harbor period. However, you could face civil and criminal penalties if you disregard your beneficial ownership information reporting obligations. Question 2. What are the penalties? What penalties do individuals face for violating BOI reporting requirements? Answer: as specified in the Corporate Transparency Act, a person who willfully violates the BOI reporting requirements may be subject to civil penalties of up to $500 for each day that the violation continues. That person may also be subject to criminal penalties of up to 2 years imprisonment and a fine of up to $10,000. Potential violations include willfully failing to file a beneficial ownership information report, willfully filing false beneficial ownership information, or willfully failing to correct or update previously reported beneficial ownership information. So that means that reporting companies have an obligation to file their reports, to file reports that are true and accurate, um, and they have an obligation to correct and update information that has changed or they've realized is incorrect, um, on their BOI report, their initial BOI report. Those are affirmative obligations that each reporting company will have. And we saw the penalties, they are stiff and they are heavy penalties. We're talking $500 each day that the violation continues. And trust me, if you're a small business owner and months go by before you do what you need to do, FinCEN's not going to come knocking on your door, 2 days after a reporting deadline. It's going to take them time. We know how the government works and how quickly or slowly they work. It's going to take them time to realize that that you haven't fulfilled your requirements. In that time, those fees and those fines are adding up. So it's going to be important for everybody to file what they need to file it on time, file it as correctly as they can with, true and complete information, and update that information once you learn of any changes to it. Who can be held liable for violating BOI reporting requirements? So, who's going to be responsible for the actual requirements? Is it going to be a person or is it just going to be a reporting company, a corporate entity? FinCEN says both individuals and corporate entities can be held liable for willful violations. This can include not only an individual who actually files or attempts to file false information with FinCEN, but also anyone who willfully provides the filer with false information to report. So if you're going to be filing the report with FinCEN, and you know that information is false, you personally could be liable for that false information that's being submitted to the government. Both individuals and corporate entities may also be liable for willfully failing to report complete or updated beneficial ownership information. In such circumstances, individuals can be held liable if they either caused the failure or are a senior officer at the company at the time of the failure. So, if you're the cause of the failure, if you're a beneficial owner who is refusing to provide your information to the reporting company that's begging you for your information, then you as a beneficial owner could be held personally liable. Similarly, a senior officer at the reporting company can also be held liable. Now, none of this has been tested yet. We don't have any lawsuits. There's no precedents. Uh, there are no real world examples of this just yet. Again, this is not going into effect until January 1, 2024. So it's not until then, and probably, several months later, that we're going to start seeing those challenges. If you've watched one of my other videos about the NSBU case, it's a federal case in Alabama that's challenging the Corporate Transparency Act on the basis of its constitutionality. But that's not getting into these finite issues of, what happens when and who's actually going to be liable in these circumstances. So that should be very interesting to see. And I will be, I'll be following those cases when they come out, because the implications of that are going to be far, far spread. Can an individual who files a report on behalf of a reporting company be held liable? Yes. An individual who willfully files a false or fraudulent BOI report on a company's behalf may be subject to the same civil and criminal penalties as the reporting company and its senior officers. Can a beneficial owner or a company applicant be held liable for refusing to provide required information to a reporting company? This is what we just talked about. Yes, as described above, an enforcement action can be brought against an individual who willfully causes a reporting company's failure to submit complete or updated beneficial ownership information to FinCEN. This would include a beneficial owner or a company applicant who willfully fails to provide required information to a reporting company. It's going to be interesting to see if there are reporting companies who decide to bring suit against a beneficial owner, for example, for his or her information. Picture this: a reporting company has to file its BOI report timely, and if a beneficial owner is refusing to provide that information, is a reporting company under an obligation to file for injunctive relief against that beneficial owner for affirmative relief? Can they bring that beneficial owner to court to say, force this person to give us reporting company, their personal information, their, passport picture, or, whatever it is, so that we can file and meet our reporting requirements? That's going to be interesting to see. Next question: is a reporting company responsible for ensuring the accuracy of the information that it reports to FinCEN, even if the reporting company obtains that information from another party? And the answer is yes. It is the responsibility of the reporting company to identify its beneficial owners and company applicants and to report those individuals to FinCEN. At the time the filing is made, each reporting company is required to certify that its report or application is true, correct, and complete. Accordingly, FinCEN expects that reporting companies will take care to verify the information they receive from their beneficial owners and company applicants before reporting it to FinCEN. The ramifications of that run deep, man. So the reporting companies are going to have to independently verify all the information that their beneficial owners are providing to them. That's that's a heavy burden. That's a heavy burden. And I feel for the small companies that are going to have issues with this. Our last question here is: what should a reporting company do if a beneficial owner or company applicant withholds information? FinCEN says, while FinCEN recognizes that much of the information required to be reported about beneficial owners and company applicants will be provided to reporting companies by those individuals, reporting companies are responsible for ensuring that they submit complete and accurate beneficial ownership information to FinCEN. Starting January 1, 2024, reporting companies will have a legal requirement to report beneficial ownership information to FinCEN. Existing reporting companies should engage with their beneficial owners to advise them of this requirement, obtain required information, and revise or consider putting in place mechanisms to ensure that beneficial owners will keep reporting companies apprised of changes in reported information. If necessary, beneficial owners and company applicants should also be aware that they may face penalties if they willfully cause a reporting company to fail to report complete or updated beneficial ownership information. Persons considering creating or registering legal entities that will be reporting companies should take steps to ensure that they have access to the beneficial ownership information as required to be reported to FinCEN, and that they have mechanisms in place to ensure that the reporting company is kept apprised of changes in that information. So this is putting the burden straight on to reporting companies to ensure that that their beneficial owners are going to be compliant. And I mean, this seems to say that reporting companies could threaten their beneficial owners and let them know that they, the beneficial owners, may be penalized for willfully refusing to comply by providing information to the reporting company. So, so I just wanted to share that information with you guys. This is going to be a burden on small companies. And I feel for them. I'm hoping that, things are going to go smoother than I anticipate. But I would just say that I think it's a good idea to give your beneficial owners a heads up, to let them know about the Corporate Transparency Act, let them know about the reporting requirements that that the reporting company is going to have to comply with, and let them know that they're going to need to provide their information to any company that they're associated with, that they're a beneficial owner of, and they're going to need to do it in a timely, complete manner, and they're going to have to keep that information updated. Otherwise, there will be penalties for their non-compliance. So, if you would like any assistance with that, I've created a template letter that I'm offering to my viewers for free of charge, that you can send out to your beneficial owners to put this on their radar. All you need to do is subscribe to my channel. Just kidding. You don't have to subscribe. I would love if you do subscribe to my channel, but it's not necessary in order to receive this this template letter. If you would like a copy of the letter, and it could just be a starting point, a jump off point for you guys. It's fully editable, so you are able to edit the text. If you'd like a copy of that, send an email to presumedlegal@gmail.com. I'll put the email address right up here, I think. presumedlegal@gmail.com, and put the subject line as beneficial owner letter, and I'll send that out to you. Now, like I mentioned before, if you want more information on the CTA, how it might apply to your company, whether it applies to your company, whether your company satisfies one of the requirements for an exemption, then check out my playlist about the Corporate Transparency Act. I am building a catalog of videos explaining a lot of terms and concepts that are going to be important for people to know and understand. And if you're a small business owner and you want legal tips, updates, general advice about how to proactively protect your business assets, hit the subscribe button. Leave me a comment below, say hello, and stay tuned. All right? Until the next drop. Peace.